For most people, filing a Chapter 7 wipes out your credit card debts or other unsecured debt, and that will be the end of it. This is true even if a creditor sued you and obtained a judgment against you. The creditor may have been garnishing your salary or freezing your bank account immediately prior to the filing of the bankruptcy. The Chapter 7 bankruptcy filing and the subsequent discharge of the debt forever takes care of that judgment creditor in most circumstances. He can no longer pursue that debt. However, many people do not know, including some attorneys, that a judgment lien may survive bankruptcy when you own a house or a condo. Thus, a judgment obtained by a credit card company, for instance, if filed in the Supreme Court of the county in which you own real property, will impact your house in the future. As an example, if you own property in the Bronx and the judgment is filed or docketed in the Bronx Supreme Court, the lien is attached to your property automatically. That means you will not be able to refinance or sell your house unless you pay off the amount of the judgment lien, including interest accumulating at 9% per year. And that can be a lot. Over the years, the number can be humongous. This is true even though your personal obligation to pay back that money has been extinguished. You cannot be sued on the debt, but the judgment lien will stay on your property unless something is done. Please note that special circumstances apply if you own a co-op and there is a judgment lien. You really need to consult a competent attorney to advise you of the law. As well, an experienced attorney will help you deal with this issue by trying to knock out this lien on your primary residence during the course of your Chapter 7 or Chapter 13 bankruptcy in a separate legal proceeding. Essentially, the lien may be avoided if it impairs your homestead exemption. As well, the lien can be avoided for both your primary residence and investment properties if the filing of the judgment lien occurred within 90 days of the bankruptcy filing. Now, these are very specific and sometimes complicated rules for voiding a judgment lien in bankruptcy, and only an experienced bankruptcy practitioner will be able to guide you through the process. If this applies to you, I strongly suggest that you find a competent bankruptcy attorney to evaluate if you'll be able to avoid that judgment during the course of the bankruptcy. It is a lot more complicated, expensive, and may not be permissible if commenced after the conclusion of the bankruptcy case. Know your rights.